Ladies and gentlemen, my name is Muthupandi Ganesan. I'm a barrister at law practicing in London, but I also practice in India as an advocate. I have the pleasure of speaking to you from an Indian advocate's point of view in relation to one of the major issues that has risen as a result of coronavirus pandemic. Of course, coronavirus has affected people's health, wealth, economy, and many other parts of people's lives. One of the major issues for businesses, individuals, is in relation to contract. And the question that people often now ask is, what do I do in terms of my contract? Can my contract be avoided? Because at present, I'm unable to complete the contract due to various travel restrictions and the inability to perform the contract. From the Indian point of view, the starting point is all Indian contracts are governed by the Indian Contract Act 1872. Of course, it has been around quite some time, and that contract act clearly sets out the basis on which parties agree and enforce a contract, which has been agreed between the parties voluntarily. The key question here is, how does a party or parties to the contract can get out of the contract because of coronavirus and their inability to perform the contract? Often people ask, what is force majeure? What does it actually mean? In simple, force majeure is a term that has been borrowed from the Napoleonic Code, and it actually stands or means effectively causes that you cannot prevent and for which you're not responsible. So what does that mean in simple terms? Simple terms, people often describe it as acts that are out of your control, that are act of God, act that you cannot in any way either anticipate, prepare, or be able to deal with, i.e. outside your control. The issue of force majeure has been in contracts for a very long time, and often contracts provide very specific circumstances in which force majeure clause applies, and that also includes in Indian contracts. Often people specify terms and conditions such as flood, storm, drought, natural disasters, civil war, terrorist attack, embargo, diplomatic relations being broken off, nuclear, chemical, or biological weapons, pandemic, epidemic, and of course, changes in law. So these are just some examples of force majeure clauses that are often recognized in contracts. But also you could have a very generic force majeure clause, which simply says, well, things that are outside their control, act of God. Now, the key question from an Indian point of view, Indian contractual point of view, how does that sit with the Indian Contract Act 1872? Indian Contract Act 1872 does not define the term force majeure. There is no particular provision as such. But what Indian Contract Act 1872 does have is what's called Section 56. And that section says that if you agree and enter into a contract, and contract which becomes impossible by reason of some event which outside your control, or it becomes unlawful, then the contract cannot be performed. And often common law lawyers use the term frustration, meaning that the contract has been frustrated. The important distinction between the opportunity that's available under Section 56 of the Indian Contract Act 1872 and the force majeure clause are these. Force majeure clause is a contractual remedy between the parties which allows them to come out of the contract, whereas the Section 56 is a statutory remedy, and that statutory remedy, basically what that does is that discharges both parties from the contract. Whereas in force majeure clause, often it does not mean a complete termination of a contract. It could simply mean a suspension of it. It could simply mean part performance of a contract. It could simply mean that some other elements of it may be curtailed or maybe performed a bit later. So these are sort of the examples of force majeure clauses and how they've been looked at in particular contracts. But in relation to Indian contract and Indian law, it is very clear the courts do recognize force majeure. It was recognized as early as in 1924 in the British Colonial Court of Madras High Court in a case called Edmund Bennett and other against Edgar Raphael Prudhomme. It was a case which related to a contract to transit or transfer or transport 400 tons of ground nut kernels from Marseille in France to Madras. And the transporter entered into an agreement to transport it, but the ship that was agreed to transport was in fact taken by the government for war purposes, and the transporter could not find any other substitute or any other way to transport the goods. And in court, the transporter agreed there was a force majeure event, and the court agreed. Clearly, the seizing of the ship by the government for war purposes and the inability to obtain other transporters meant that they were not able to perform the contract, and they were released from the contract by way of force majeure clause. Since then, the Indian courts have consistently held that in the event if there is a force majeure clause in a contract, then Section 56 has no application to it. And what in a case called Energy Watchdog against Central Electricity Regulatory Commission and other in 2017, the Supreme Court held that when a contract contains a force majeure clause, which on the construction by the court is attracted to the facts of the case, then Section 56 has no relevance and has no application. So what does that mean? It means that any use of force majeure clause must be considered on a case-by-case basis, and it must be proved by the party seeking to rely on it. In India, on February the 19th, 2020, the government of India made it very clear that as far as they're concerned, force majeure event has arisen, and in that they defined coronavirus pandemic as a natural calamity. So there is a clear evidence for parties to rely back on to say an event has occurred, if that's what a party wishes to do. But what is really important from the Indian law point of view is that there must be a very clear notice given to the party that seeks to rely on it to the other party. In a case called Raichur Solapur Transmission Company Limited against Power Grid Corporation of India in 2016, the Supreme Court held very clearly that it is absolutely mandatory for the party that wishes to rely on it to give notice. Failure to do so will, of course, stop the ability to claim force majeure clause and the ability to claim the relief under that. So what are the practical considerations from an Indian advocate's point of view? It is, of course, crucial, just like in any other jurisdiction, to look at the contract very carefully, to read the clause very carefully, and to demonstrate that in order to rely on the force majeure clause, you must ensure there's a causation between why you're not able to perform the contract and the force majeure clause in the contract, which needs to be considered in conjunction with other provisions of the contract as a whole. In addition, the other thing to consider is whether the changes in law is something that will be of aid to you. For example, in India, under the Disaster Management Act of 2005, number of provisions have been made, a number of variations has been made under that act in support of lockdowns, in support of restrictions on travel, in support of businesses operating. So if that is something that a party must consider to see whether it assists in actually relying on the force majeure clause and the relief that may be contained under that. Those are in relation to the contracts already in existence, and a party may wish to rely on that. The other aspect of the force majeure clause at present is to consider if you are entering into a new contract, how does that work in the climate of pandemic, where coronavirus is currently a significant concern across the world? And I go back to the 1924 case, which was in fact a case that was a contract that was made during the First World War. So yes, a contract can be made, but it is absolutely imperative that any new force majeure clause is extremely carefully constructed and drafted to ensure that in fact it has the desired effect and validity and the enforceability that parties actually want. So the key message from force majeure from an Indian advocate's point of view is, in a summary, force majeure is recognized in India. It has been ruled upon previously. It sits alongside the principle of frustration, but the key thing is each contract must be considered very carefully, and any new contracts must be drafted with very clear and good drafting to ensure that it will achieve its stated purpose. Thank you for listening.